Yes, Your Honor. If it may please support counsel. I'll be the jury. I want to start our discussion this morning with a simple thought, a simple premise for you. And that is that Mr. Balea didn't create this world. He didn't consent to being recorded. He didn't consent to this posting. More extreme level of that is he wasn't even called before this was put up. And we talked about journalism a lot in this case, and I'm going to get deep into some of these journalistic standards where lines are supposed to be drawn between journalism and privacy, but I'll give you the simple thought that most of the time in a news story, you see that little ending part where it says, so-and-so was contacted and had no comment, or so-and-so was contacted and said this. The idea that in September of 2012, this video was sent to Gawker, and they didn't have the common decency to call one person that was involved in it before they posted this story, probably tells you as much as you need to know about Gawker and whether that company and Mr. Delario and Mr. Denton deserve protection under our First Amendment. That being said, I want to take you back to September 2012. And I want you to think about this for a little bit as a background on everything I'm going to talk about. Think about where this starts when Mr. Delario gets this email from Tony Burton, an agent who represents Mike Calta, a DJ who lives in this town. You know, when these trials go on, you get sort of all this stuff around the real core of it, and the fact that it's Mike Calta, who Burton testified had some radio battles with Bubba the Love Sponge, may add some flavor to it or atmosphere. But the truth is, all you really need to know is A.J. Delario gets an email from this guy telling him he has a, quote, significant DVD. You may remember the email. It wasn't one of the longer ones. It just had a line on it. I have a significant DVD. They go back and forth, and he tells him it's anonymous, right? Now, this is a reporter, purportedly. This is a reporter who's supposed to be doing a news story. That's how this all starts, right? They exchange the emails. He gives him a P.O. box. He gets a package. In the package is this, quote, significant DVD. Now, what's significant in the world of Gawker is a tape of my client in a private bedroom with a friend at the lowest point in his life, in a private act, and we can just call it that. I think there's been enough language in the case that we know what private act means. That they know at the time, at least what they know at the time, is that it was secretly recorded. Whether they believed it's irrelevant, because in the article, Delario even says Hogan claims it was secretly recorded. They do nothing by way of trying to find anything out. They don't even call my client. And then they spend the next 2 or 3 days joking about him, making fun of him, of how he looks, of his anatomy. They want to make jokes about his character and whether he's wearing a do-rag on his sexual organs. You know, a bunch of, you know, frankly, let's call it for what it is, a bunch of young kids sitting there in what they call their campfire chat, taking a private act in a private place and using it to joke. That's the background against which this serious journalism that's supposed to be protected by the First Amendment starts. Mr. Vogt used the word power, if you remember, in opening, and we try and link these things up so all this makes some kind of sense to you. And Professor Foley used it too, and it's something he said on the witness stand, that the media has the ability or the power to do great good and the power to do great harm. And against this idea, this mocking of Mr. Balea, a defenseless Mr. Balea, because, by the way, they don't call him and he's not there. They don't know anything about the background of what's going on. They have no idea that he's in the lowest point of his life. His wife has left him. And we're going to talk more about this idea of Mr. Balea, the person, versus the character he's played for 35 plus years. Mr. Delario sits down at a computer with his friends, joking, laughing, mocking, recklessly, consuming this content, and with a click, uploads this thing out into the internet and turns this man's life upside down. Now, there's not one thing about that that Terry Bollea created. Not one thing. Not even the simple idea of calling him to say, we are going to do this, whether you like it or not. Do you have a comment? What's this about? Did you know, did you not know? We've heard you didn't know. That's the background against this case. Now what happens after he clicks it? Traffic soars on Gawker. I don't care, and I'm going to talk to you about all the experts and the traffic issues and the various ideas of why they did this. But we can agree on one thing. I don't care how many Peter Horans they put on the witness stand to say this didn't matter. Their traffic stores. It becomes what they have described as a defining story. Do you remember that? Defining story. This is Gawker, the Gawker network. 8 different websites, Gizmodo, IO9, all of this content going out under the Gawker umbrella, and this is what defines them. And we're going to talk in great detail when we get to the damages part about what that means and what they try and say it means. But we know they called it defining. Real time. Before the lawyers got involved, before there was a lawsuit, real-time people talking about real-time things, and that's another theme that we'll talk about. They did this all at the expense of a man they didn't know. They thought they knew him because he's played a character for 35 plus years, and I'm going to talk about that now. If you could pull up 49 and 119, John. Should be 49, the cease and desist email. And if you could highlight the part, I think, go down. Right here. I did not want you to think I was attempting to bully you or make demands that were not warranted. I am asking you to remove the same. I am simply advising what our next steps would be. It is not meant to threaten, but rather as an advisement as to what we must do to protect the image of Hulk Hogan and his privacy rights. If you look at the letter, they made this like kind of issue, by the way, that says Hulk Hogan. And the first paragraph says Terry Bollea, known as Hulk Hogan. I think Mr. Houston made that clear. But look at this paragraph, and this is really what I want you to focus on because we're going to talk about it an awful lot this morning. I am sure you must understand as a human being exactly how offensive this seemed to be. Despite the fact this would have been presented to you anonymously, it is difficult to believe you were not aware this was done without his consent and or knowledge. And if you go down, Mr. Houston finishes this and says, I have no intention of attempting to harm you or your business, but rather protect my client. The letter he sent with it, if y'all remember, is more of like a legal letter. And at the end it just says, take it down. And when Mr. Houston testified, he said, I just was trying to be decent. I was asking them to do the decent thing. This wasn't about a lawsuit. Just take it down. You have real-time evidence of that. And so when I talk about the fact that this isn't a world Terry Bollea created, both at the start of when this began with the anonymous DVD up until Mr. Houston's letter, all that was ever asked was Gawker be decent. We know Gawker and Dent and Delario weren't decent because, you know, basically they're just not, and they're proud of it. I mean, they boast about it. They boast about breaking rules and about doing indecent things because, you know, the philosophy of the place is run by a guy who literally believes we don't have privacy rights. I mean, he said it. And I'm going to go back through that evidence. I want to talk to you about Mr. Bollea. You know, this concept of the Hulk Hogan character in Mr. Bollea and where that starts and ends, I know you've heard a lot about it, and at times it must have seemed strange to you or over the top, and other times it must have made a lot of sense to you. It should make sense to you because I want you to imagine the fact that for 35 plus years, he is essentially an actor, an entertainer, who has played the same role. Now, I want you to apply that. Think of all the movie stars you've ever heard of, and imagine if they were fortunate or unfortunate enough to have one role they played for 35 plus years. Think of Captain Kangaroo. Do you think Captain Kangaroo, maybe a little dated there, I'm sorry. It's what popped into my mind anyway. Do you think Captain Kangaroo, anybody thought what his real name was? Or Dr. Seuss, to the extent he was recognizable in public? He's got a real name, right? They have real names. It's the difference when you're one of these characters. And I'm not going to make excuses, and Mr. Bollea never did. He never said he was upset about being Hulk Hogan. He was fortunate to have that opportunity in his life. But imagine for 35 plus years, the same role. of an actor or a character. And that's why you hear this so much. And it's hard for him to explain sometimes. You know, and it would be hard for anybody to explain. Because when he leaves his house, because he's been the same character for 35 years, nobody cares who Terry Bollea is. They just don't. Terry Bollea is a kid who grew up in a pretty nasty working class area in Tampa, okay? You know, who was really more of a musician than an athlete. And fortunately or unfortunately, because he was so big, fell into sports because the coaches wouldn't leave him alone. I think they're going to send back his autobiography with you, okay? And I want you to look at it. Because he talked about how self-conscious he is and why he wears a bandana. See, you know Hulk Hogan. He wears the yellow bandana, rips it off on stage. It's a big deal, right? It's part of the act. He wears it because he's self-conscious about the size of his head. And if you look in there, there's a picture of him in Little League Baseball with a comment underneath it about how he couldn't get a helmet to fit his head. It's not, this is the truth. This is what he is. And so he saw a better life for himself, and he hawked a bunch of wrestlers and followed them around like a fan. You know, until he got this opportunity. And you know something? It wasn't handed to him. He broke his leg training to be a wrestler. This is a guy that worked for everything he got. But Terry Bollea, the person, you know, he's a regular family guy who grew up in a pretty simple background, who's been lucky to have had some success in his life, but equally speaking is a guy that when his wife left him, was so sad he hadn't had a home-cooked meal, that Heather Clem, and all of that dramatic testimony she gave was one thing she remembered. How was he? He was sad because he hadn't had a home-cooked meal. That's the person. And you know, the person has every right to keep whatever precious private moments they have in their life, which for this gentleman are very few. Can't trust a lot of people. He can't have a lot of friends because everybody wants the actor. They want the character. They want Hulk Hogan. And behind closed doors, he's just a guy who's sad he hadn't had a home-cooked lunch. Yeah, that's not his testimony. You didn't hear him. He wasn't trying to grandstand for you about that difference. But sometimes in these trials, what happens is these little organic facts come out. You know, and if you don't see that distinction right there from that testimony, look at Jules Wortman. Could you pull up 17? I found this email to be somewhat illustrative at this point for you, right? By the way, Miss Wortman is not his publicist. She works for TNA, okay? She works for the corporation. This is her, if you look down there, sending an email to Mr. Bollea about the Bound for Glory tour. And it says, to Terry Bollea, here you go, Terry. Please note the attachment accompanying the itinerary. And look at the attachment. What does it say? Hulk Hogan NYC Media Tour. Talking about the character in the third person. This is Miss Wortman, and you heard her testimony. When he goes on the show, he's always the character. When he goes on Stern, he has no control. You play the game as it's played, and we're going to talk more about some of those shock jock shows. But, you know, the bigger point here is you have to grasp that fact for a moment, that there is a true difference between an entertainer who's played a role for 35 plus years and having privacy in one or two places as Terry Bollea, because he doesn't have it in many. And obviously one of the places he thought he had privacy was in a private bedroom at his best friend's house in 2007. He's never complained about his anonymity. He's never complained about sacrificing that. He knows that when he walks on the street, selfies are coming, autographs are coming. Hey Hogan, hey Hulkster, he's got to flash a muscle pose or something. He's embraced it. He's never complained about it. This case has nothing to do with that. It has to do with those little areas that we all agreed in jury selection that even a celebrity gets to have. And I think you all remember that. We talked about it. How many, I asked a really broad question back then. How many of you believe celebrities just waive their privacy rights? Right? We all agreed that people generally agreed that celebrities still have some privacy rights. Even Mr. Denton, with his thoughts about privacy, agreed to that, about that. The defense, I want to talk about Gawker and Nick Denton a little bit. Actually, I want to talk about them a lot. You know, pull up number 37 if you could, John. You know, this idea of the First Amendment has limits. You just heard the law, and the judge talked to you about the balancing test between privacy rights. When does it stop being information to which the public is entitled? When does it become a morbid prying into somebody's life? I don't know if you remember that. It shows you like 28 pages of stuff. You'll take them back there. It's in there. That's the balancing test. You'll see this long instruction on what newsworthiness means. And right at the bottom, it'll tell you in balancing privacy versus newsworthiness, here's what you do. I want to start about Gawker with what Nick Denton says. The theory is, the philosophy. And if you remember when I had him up on the stand, I asked him, your philosophy about journalism is reflected in the company. I don't know if y'all remember that particular question, but he was very proud. And then I got kind of testy with him, like, you founded it, right? You're the owner. That's your ethic, your philosophy. You created this world. We don't seek to do good, says Denton. We may inadvertently do good. We may inadvertently commit journalism as if it's a crime to commit journalism, because he's so proud of being the guy who ruins lives with these, quote, cutting-edge things like a private sex video. That is not the institutional intention. Do we all know what that means, the institutional intention? That is not what I have made the institution desire to do, desire to be. We don't want to commit journalism. Maybe if I mistake every now and again, we do that. And what's funny about that is when they come back later in the trial and they put up this Adam Lanza article and boast about how great it is when they didn't even write it. I don't know if y'all remember that thing. We had a big lawyer thing going on there. Like at the end, I wanted them to show you, hey, it's been republished. You didn't write it. You know, we're proud of that at Gawker. So we go into this idea that Gawker is the reflection of its owner and founder, Nick Denton. And that's what they had chosen to be at Gawker. We hear his signature test, the line, the test. John, could you put up 375? You know, this is another piece of evidence that, you know, you're in here for 2 weeks. I don't know what you really pick up on and do. Part of closing is to try and talk about that with you all. But this was his tweet. The line, the test. The story should be true, and it should be interesting. And I said, there's nothing in there about it should respect privacy rights or do the balancing test that Judge Campbell just read you, right? And we talked about that back in jury instructions. You know, there was questions, I don't know if y'all remember, you know, kind of in the dialogue about where does it start, where does it end? And everybody, the lawyers will tell you, they'll say, you know, the judge is going to tell you where you've been told this morning. Where does it start, where does it end? And I asked him that. And then remember, he adds this thing in, and check with legal. Now, in his career, this is like his signature line, okay? It's in other articles, you can see it everywhere, you've heard it in the case. He has never said, and check with legal. He's never said it. He said it to A.J. Delario on the fire escape when A.J. was about to turn Mr. Belea's life upside down, right? That was the one thing he remembered. We talk about the fire escape discussion. A.J. says it doesn't happen. Denton says, I have a hazy recollection. I think it happened. It may have happened. I remember him being excited. No, I don't remember him being excited. We had to go to the deposition. I don't know if you remember. It was one of those deals. I remember talking to him. Wait, I don't know if I talked to him. It may have been before, it may have been after. The truth of the matter is they're going to circle the wagons around Denton, and Delario is going to get on the stand and say, I never talked to him. Denton swore under oath he talked to him. Because the one thing he remembered was what? I told him to go talk to legal. He talks to legal. We ask him, what did they say? Objection, don't answer the question. Y'all draw your own conclusions from that. You know, you may wonder, and you may not, but you may be wondering why. Why would somebody create a company that's supposed to be in the media to do this? You know, what is the kind of goal? Obviously, we think one of the goals is to make a ton of money, all right? To go move your offices to Fifth Avenue when you're paying $3 million a year in rent, $280,000 a month, because you're bursting at the seams. That's obviously a reason. But the bigger reason, the kind of Nick Denton reason, you know, how's the machinery working up there? It's this idea that this guy has that society somehow has changed and nobody has privacy anymore. Pull up 115. One of y'all questioned him. Sometimes amazing questions you guys ask. Because one of you guys questioned him, and we don't know whose questions are good, so you send them up there, and said, do you think, actually I want to read it because I don't want to mess it up. Here we go. Do you believe that non-celebrities have the right to privacy in their own bedrooms? The witness, yes, I don't think it's newsworthy to do a story about a private individual with their partner in the privacy of their own home. I don't know if y'all remember that. I'm sure one of you does because someone on the jury asked the question. And he said, I don't think that's newsworthy, right? And I didn't know at the time if anybody remembered this, which I'd already put in on his cross. One of the legal issues that the reporter asked, that's always coming up for Gawker again and again and again, is privacy issues. Do you have a larger philosophy on privacy? I think the world, he says, is coming around to our presumption on privacy, which is that when somebody becomes the publisher, as people do at quite a young age on Facebook, to the extent that they are published and they are viewed, they become some sort of public figure. That blurs the line between public and private in a way that has never been done before. They ask him a question. You've been accused of invading people's privacy, from George Clooney complaining about Gawker stalker and the Hogan sex tape. Just once in a while, Denton says, I think it's worthwhile to take stock and recognize that the supposed invasion of privacy has incredibly positive effects on society. So when he answered that question from one of the jurors and said, oh no, private people, that's not what he's telling the rest of the world, trust me, it's right up there. You go on Facebook, you're some sort of a public figure. And he said other things like that because of social media. Everybody's some sort of a public figure. Privacy invasion has a positive effect on society. Who thinks like that? What kind of engineering is going on in the mind of somebody who thinks it's a good thing to invade people's privacy? If we look, number 30, John, I mean, this isn't just a casual thought. It defines the whole reason why we're here. Because it answers for you why he would do what he did to Mr. Balea. I mean, this isn't just like Nick Denton waxing poetic to some reporter. I mean, the guy likes to talk, I get it. But he gets a direct question when he's interviewed by Playboy. Is it possible you set a lower value on privacy than most people do? And we get this answer, and I'm not going to read it again. You guys see it. I'm kind of sick of it. Language, but I don't think people give a blank about it, actually. You know, and he talks about something where he thought was going to happen to him. He says, then Playboy asked him, and you weren't freaked out. And he says, it would have been mortifying, admitting that he kind of understands what it does to people. But his thought, every infringement of privacy is sort of liberating. Afterward, you have less to lose. You're a freer person. Shouldn't we all want to own our own story? I am certain that everyone in their private lives wants to decide what they get to make public and private. And notwithstanding the fact that Terry Bollea is an entertainer who plays the role of Hulk Hogan, I am pretty sure everybody here can agree that the simple thought of being private in the bedroom of your best friend's house is something he should want to own on his own terms. I don't think that the idea that Nick Denton puts in a Gawker, that he gets to choose when people are private and when they're not, is something the First Amendment protects in this case or any case. This is Nick Denton on privacy. This is Nick Denton who believes that once you've bottomed out because somebody's exposed your private life, you are now free. You can not worry about anything else because your life has hit rock bottom because somebody's taken your private facts and put it out there. Look at number 9, if you could, John. This was another sort of snippet of Nick Denton on privacy, another quote to another reporter. After that Hulk Hogan sex tape on Gawker, I can hardly complain about intrusion into my private life. Yep, love is messy. You see, that's as much an admission of Denton knowing that they intruded into Terry Bollea's private life as anything. That frames how he's thinking. It's not, I'm sorry about it. It's in Nick Denton's world, I'm not going to complain about it now, except, you know, we kind of talked about this hypocrisy as a sin, and I know it was kind of a silly point, but it's kind of funny that when he gets married, nobody's allowed to bring their cameras in or tweet on social media. And he kind of responds flippantly like, oh, we didn't sue them. That's not the point. The point is this guy's up in New York sitting behind a computer playing God with other people's lives. And when he gets to control it, even in something as simple as a wedding, a public event, nobody's going to tweet, nobody's going to take pictures. Hypocrisy being his sin. So you know, how do they get this done? What is the the rules of the game for Gawker. I mean, we talked a lot in this case about the idea that there are rules. You know, I don't know if y'all remember, it was a long time ago when we had voir dire. I did warn you it would be the only time we could talk back and forth. So when we were doing that, I asked y'all at one point, do you think the media can do anything they want? And I don't know if you remember, it was like 3 weeks ago, but we had a discussion about whether there were some rules, you know, whether there were some guidelines. One of them is the balancing test Judge Campbell read, right? That tells you the newsworthiness test. Another one are Gawker's internal guidelines, at least to the extent they say they're going to follow them. They don't, but it's interesting to show. And if you look at 233, we saw these content guidelines, which Gawker puts on its website, telling its users, don't publish a porn site, respect privacy, make sure you own the rights. And this has been applied to Gawker, and they've acknowledged that these guidelines are in place. Of course, they don't follow any of it. You heard in response to a jury question, I think one of y'all asked him, do you think gratuitous content is protected by the First Amendment? And he said no. I think that was a jury question. And he's admitted, Denton did, that the Valleja sex tape excerpt was pornography, if you remember that. NSFW, watch it anyway. Why did you put that up there, Mr. Denton? And he says, well, because it's pornography and you get fired at work for watching pornography. Respect the privacy of others. Make sure you own the rights to anything you post. This is purportedly what happens inside of Gawker, although they don't follow one of those mandates. We showed you other examples of this and how they do this. And the reason why they don't follow them is because they've admitted, you know, being rule breakers. I mean, they love being rule breakers. He loves A.J. Delario. Denton praises this guy because Delario is a rule breaker. That's the whole premise of how they do things there. We're going to break the rules. We're not going to commit journalism. If you pull up board G9, this is 3 or 4 different pieces we had, you know, into evidence here. You know, this came from Professor Foley. You know, if you want to distill Professor Foley, you know, a highly decorated, respected, award-winning journalist who teaches in Florida, distill it down to this simple concept. Be decent. Be decent. Think about the effect of what you do on the subject of your stories. Don't do things that harm other people unless you have to, which is the question one of y'all asked, which is something gratuitous. Was it needed? Gratuitous means unnecessary. It's the same word, right? Denton acknowledges this, that gratuitous isn't protected by the First Amendment. But then we look at what Delario posts, which Denton has described as sympathetic and sweet, humanizing. And Delario, the whole thing says, because the internet has made it easier for all of us to be shameless voyeurs and deviants. I'm not so sure all of us are shameless voyeurs and deviants. They may be up on Fifth Avenue at Gawker, but that's a little bit of an assumption for the rest of the world. And we say, when we watch this footage, because it's something we're not supposed to do, what could be a better admission that it was gratuitous than that? And so you have Delario admitting that this shouldn't be protected by the First. And then you have this idea that they have these guidelines, and it all matches up with what Professor Foley said. And look, this isn't the law, these standards that he put up there. We're not claiming that's the First Amendment. It's just guidelines and standards of practice that the responsible world of the media is supposed to adhere to. And so you want to distill it to some of the things that Professor Foley said. Avoid pandering to learned curiosity, even if others do, right? And, you know, for as much time as they spent cross-examining that man to prove to you that what? The Demi Moore art shot on the cover of Vanity Fair was fair game under the First Amendment. I mean, let's be honest, okay? That was on the cover of Vanity Fair. She's covered up. Has nothing to do with this case. They used like 5 examples that were all like that. People who had consented or were paid, actually, for the shot. You know, and then they attacked Foley because he wrote an article saying, hey, I know it's a little edgy. I mean, think about that compared to what happened with this sex tape here. Pull up, if you could. Is that to an hour? Yeah. All right, pull up, you know, if you could, number 60, because I want to talk about Delario right now. I want to wrap up that last point with this simple premise for y'all. Whether it comes out of Professor Foley's mouth, all right, whether it comes out of basic journalism practices or the law that Judge Campbell read you, the simple premise is be decent. Be a reasonable person living within a civilized society. And reasonable people in a civilized society don't take secretly recorded sex tapes from a private bedroom and send them out to the world. That all comes together in these jury instructions as well as the evidence. We talk about Delario in this idea of being a rule breaker, and we look at what he said, why he's a rule breaker, and we look at this Exhibit 60 that came in, and he's getting interviewed like he was a lot at various times. It becomes so commonplace, he says, to criticize what we do and focus on the ethics when the reality is, I work for Nick Denton, the founder of Deadspin's parent company, Gawker, who doesn't adhere to those rules. If I worked somewhere else, would I do that? Probably not. But people want me to adhere to the rules at their job instead of what I'm asked to do here. We don't adhere to the rules. If I went somewhere else, I would. But I work for Nick Denton. He breaks rules. That's what I do. That's what this means. It's not like this is confusing to them. They wear it. They're proud of this idea that they don't adhere to the rules because ultimately what we're going to talk about is it drives traffic and it makes money. If you pull up 138, Denton's so proud of his protege. He's so proud of him. He's brilliant. He's oftentimes infuriating. He's bold. I think he called him a leader of men at one point in time. It's not on this memo. And I don't fully understand. AJ breaks the usual rules of orthodox management and has still been the most successful editor of Gawker.com. You talk about the proud mentor. I mean, this guy is the epitome of what Denton wants. He could care less about whether he's doing anything responsibly under the First Amendment. He is Denton's golden child. His creation that does everything the way he wants and is bold but infuriating. What we know about him is that he's someone who sets the standard of newsworthiness at the publication of sex tapes of 5-year-old children. That's what we know. And you know something, they can say he was joking or being flippant all they want, man. I don't care. He had 30 days to correct that deposition. It was under oath. He knew it was under oath. And the question he was asked was, when is a sex tape not newsworthy? And he knew, and Mr. Vogt got him to concede, that he knew newsworthiness was a main issue in this trial. So this, I was being flippant, I was being, I don't know the other words, I was joking. It's not like this was, he was asking him a background question about where did you grow up. Man, this was the central issue in this trial. A.J. Delario draws newsworthiness at the publication of a 5-year-old sex video because it's a celebrity. And they want to talk about First Amendment and wrapping the Constitution around this guy. Please, please. Later on in the same depo, should you have any doubt about the seriousness of this guy's, mindset, to call it that, Mr. Morrell asked him, and this was part of it all, or I think Mr. Vogt had asked him on cross, would you publish a Miley Cyrus sex video? And his response was, is she over 4 at the time? Or is she over 5, I think? This was not a joke to this guy, okay? And if it was a joke, man, he had 30 days after that deposition to correct it, swear to it, and change it. The truth of the matter is he doesn't care, and you saw that. You're reasonable people, and you come in here with your common sense, and you saw this guy trying and dancing around his testimony. That's one thing you do bring in here. We talked about the fact that we want your life experiences, but not really life experiences that are related to this case. That was a jury selection thing. We want you to be able to look at this impartially, but you are allowed to use your common sense. And when Judge Campbell instructed you on the believability of witnesses, one of the things you're allowed to take into account, were they frank on the stand? What was their demeanor? Was their testimony jibing with other stuff? How did they act? Common sense, the way in your daily lives you review people and whether they're telling the truth. The case in some respects can literally end with Mr. Delario's testimony as it relates to newsworthiness. John, could you get the clip up? Don't put it up till I put the board up. Because at the end of the day, John, do you have the clip? Okay, don't hit play yet. This is a list of every reason Gawker gave for why this tape was newsworthy. If you remember, he said he talked about it on the shotgun shows, and he had the books, and he talked about his sex life, and that's why he wanted to publish it, okay? So we went ahead and asked the agent about every single one of these topics, because he was the guy writing it, and he was the guy publishing it. And we wanted to see what he had to say. John, go ahead and play it.
Our question as of October 2012, the sex tape existed, correct? Your answer, correct. And so the existence of the tape then was not news as of that date. Your answer was correct, right?
Correct.
And in fact, Mr. Valea had actually verified the existence of the tape before you posted it, hadn't
He had verified the existence of the tape?
he? Yes.
Yes, he had.
Stop 1 second.
So really then, out of your points A and B,
Just a simple point there. Terry Bollea never denied that this tape existed. Okay, this idea that they were trying to show that there was proof in the tape is I mean, he's admitted it. Okay, I don't know if y'all picked that little issue up, but Delaire even knew that at the time he wrote it. Go back.
story was to commentate on when witnessing the tape, wasn't it?
Yeah, because it was newsworthy.
We're going to show you.
It was not a question as of October 2. Valea's students had no news value, did it?
Mr. Burroughs didn't have any regard, is that what you just said?
Yes.
No.
His penis wasn't newsworthy, right?
No.
And you also wanted to be sure that your readers saw Mr. Valea and Heather Clem having sex, right?
I did.
But there was no news value to the positions that they had sex in, right?
No, not necessarily.
And you also intentionally included their conversation that they were having in that private bedroom, right?
Yeah, I just included conversations to match up with stuff that I was speaking about in my case.
And the fact that Mr. Valea was taped having sex with his best friend's wife, that wasn't the news of your piece, was it?
Sorry, can you do that again?
The fact that Mr. Valea was taped having sex with his best friend's wife wasn't the news of your piece, was it?
No, not necessarily.
I believe you were asking questions earlier about public statements that you had heard that Mr. Valea had said prior to your posting, right?
Correct.
And you talked about your knowledge of Mr. Valea's wrestling career.
Yeah.
Okay. Your article doesn't make any mention about his wrestling career, does it?
No.
Doesn't make any mention of any statements that Mr. Valea had made on the Howard Stern show, does it?
No, it does not.
It doesn't make any mention of Mr. Valea's autobiography, does it?
It does not.
Doesn't make any mention of Mr. Valea's wife's autobiography, does it?
It does not.
Doesn't make any mention of any things that Mr. Valea had said or images that had been shown on his reality show, does it?
It does not.
In fact, you weren't even aware of statements that Mr. Valea had made publicly about most of those things when you posted this story, were you?
In terms of what?
Things that he had said about his sex life. You weren't aware of statements like that, right?
Not necessarily, no. I mean, I heard him on the Howard Stern show after the fact.
But you weren't trying to disprove anything that he had said publicly in your piece, right?
I wasn't trying to disprove anything he had said publicly. All I was trying to do was show the portions of the tape that I thought were interesting and then write about the tape that I watched.
Show the portions of the tape that I thought was interesting and write about what I watched. Gratuitous, not protected. What is that, 10 reasons? That's what we've heard in this case. This is why it was newsworthy. The best one was this idea, because they showed you all these clips of my client going on the Howard Stern show, or they played him from Bubba's show, and this idea, it's hypocritical. He talks about his sex life. We're going to expose it, right? That's not what they did. That's not what he was doing. Literally, the guy has said the only reason I did this was to put the tape there and write about it. And, you know, I understand the fact that listening to these shock jock shows isn't fun and it's raunchy, but you heard the rules of the game. You heard it from Workman, you heard it from Heather Clem, from anybody who talks about it. It's all scripted or lies. It's there for shock value, and if you're the guest on the show, you play by the rules. I'm not making excuses for him. He knows every time he walks into a studio of a shock jock show as Hulk Hogan what the game is. But it doesn't matter. They want to play that stuff with you because they want you to hear Hulk Hogan on a radio show doing a skit that has to do with something that's kind of raunchy, in hopes that you go back there and you judge him morally for that. All right? Just look at the board. The only reason they're actually showing that to you is because they're saying that's why they wrote the story. And it's not. Delario admitted to you under oath it had nothing to do with it. We talked about the fact that jury selection, the moral misgivings that may have occurred in Mr. Belea's private life were not going to be something we judged him for. And I talked to you all a lot about it because he's an imperfect human being, like most personal people are. Hulk Hogan surfs on tiger sharks. He body slams elephants, okay? He is a larger-than-life icon internationally. There's a difference. And the truth of the matter is all the shock jock stuff doesn't matter because Delario told you it didn't matter. Denton admits it, you know, this whole idea that Denton talks about it's NSFW, but watch it anyway. And we talk about, you know, this idea of what does it mean from a privacy perspective? And is it a morbid and sensational prying into someone's life? And that's the jury instruction that you get on how to balance privacy versus First Amendment. They tell you that's what you do. They've admitted it. Denton's admitted it. Delario's admitted it. He has said, you know, the only reason I did it was to put the video out there and then commentate on it. We know what the commentary said. You know? I mean, look, it's as painful as it may have been at times to listen to Denton read that trash into the record here. The reason I had him do it was simple. He described it as sweet and sympathetic and humanizing. And that's how he described that. You could have at your disposal the entire English language and choose any word that has ever existed since words were created and not find a more inappropriate word for that trash than humanizing. If anything, it may be the most dehumanizing and insulting content that you could possibly have written, like a cheap, bad penthouse forum. And he's proud of it and we boasted about it. That's why I made him read it, to illustrate for you what hypocrisy is. Because you're entitled to see that as a jury. You know, at the end of the day, we're not suing on the words because Hulk, in his radio shows that he was on, newspaper articles that wrote about it, he owned it. He said, write about the tape. Okay, fine. Write about the tape and it exists. That's why TMZ was okay. The Dirty puts a screenshot. It's not like this guy has this thin skin. He was okay with the idea that there was a discussion out there about the tape. But that humanizing text, that sympathetic text, are you kidding me? Come on. I mean, what's disturbing about Gawker isn't what they do in a vacuum. It's how proud they are of it. And that this guy who's like an executive of this gigantic media company would tell like anybody that that's sweet and sympathetic and humanizing. I mean, that's the mindset. Pull up the line board if you could. You know, we put up there for y'all to look at just a little snippet. Mr. Vogt showed you all this on jury select. Opening statement. Morbid and sensational prying into private lives for its own sake, with which a reasonable member of the public with decent standards, right? Now balance those three things. That's the law. Underneath the law is the Denton test, which we talked about, and to the right of it is shameless voyeurs and deviants watching something they're not supposed to watch. Think about that. It's not Gawker's audience. It's a reasonable person of the public with decent standards. And the word decency shows up everywhere. It's just decency. It's common decency. It's what Houston even tried to do. Just be decent. So the response to all this from Gawker is this mishmash of sort of misleading stuff, starting with the fire escape. You know, it happened, it didn't happen. I mean, you know, at the end of the day, you can assess the credibility of it. What's important about that? I mean, Denton remembers it. You know, he remembers it. I had to bang him like 5 times with questions to get him to admit that at least he told him the one thing he definitely remembered was sending AJ to legal. This idea, you know, that they're trying to dance around that conversation is kind of circling the wagons around the boss, so he's not responsible. You know, he builds the house, he builds this boat, and then all of a sudden when it's sinking, he wants to jump off into a lifeboat, and that's what that is. Truth is, it happened. He knew it was going to get published. AJ was excited about it. The next thing is this idea they try and push by you. Pull up D541. Go to the last page. This is the Adam Lanza story. I mean, I know it may be a small thing, but this is Gawker trying to pretend they're real. And so they say, oh, we wrote this brilliant story about this mental health issue, and they're bragging to you about it. This was written by like someone else in a different journal, that they just like cut, paste, they get permission, they click it out there, like they're some kind of pioneers of cutting edge journalism. This is the best they came up with in this case. The Gizmodo thing, I'm sorry, you know, at the end of the day, they're bragging all about the fact that they bought a stolen iPhone from somebody and they knew it was stolen, and they go ahead and write this, you know, expose on it, like they did some cutting edge, you know, investigative journalism. And then the other thing that really sort of should tell you the straws they grasp at in this case is Denton and Fleshbot. You know, you got this big thing, I lived in Eastern Europe, I was educated at Oxford, I wrote for all these brilliant financial things, and he leaves out the part that he was a porn king, like just conveniently, and sold that company the exact same year that they decided to start putting up uncensored sex tapes on Gawker. Did you get that coincidence there? He sells it in February 2012. And by October 2012, Gawker all of a sudden is getting uncensored sex tapes that used to go over to Fleshbot. The whole thing with Sandy, you know, we'll look at some of those graphs, but at the end of the day, you know, this idea, they talk about there was a spike, but October wasn't good, and then all of a sudden they conveniently leave out the fact that this gigantic storm put their servers out of issue for like 5 days or 3 days or whatever it was. And then the other thing, and I don't know if y'all picked up on this either, was they challenged Anderson about this data. You can't tell us exactly how many uniques came from this. Well, they leave out the part where Anderson like asked for the data, and they don't have it. And we asked their own witness, that Kidder, and he says, yeah, we don't have it. But they try and create this idea that somehow Anderson was dodging, you know, the issue here. So all of that comes down to damages and why they do this. You know, why? Why all the, you know, this filth and the charade and this, you know, ridiculous journalistic ethic? You know, why would somebody do this? And the issue is very clear. Traffic. It's traffic. I mean, it's traffic. If you didn't get the point that no matter who was talking up there, traffic was important, then we did a horrible job in this case. Because every single one of them said the same thing. Denton said it. Horan, their own expert, said it. Certainly Anderson said it. You don't get ads without traffic. You have to go to the advertisers and package up how many hits you get, your unique views or your page views, so they advertise. It's simple. It's common sense. Advertisers don't want to buy ad space on publications or internet sites that don't have readers. So they want to drive traffic. Real simple. If you could pull up 127. You know, it's interesting to me for a company that has said that, you know, and for the defendants to say that they've done nothing wrong, they spent a large part of this trial trying to talk about the fact that there was no value to this defining post, okay? But we know real time, before the lawsuit, 5 days after, or 6 days after, we get this email from Nick Denton where he talks about the fact that the news had been dead for months. Remember that? 5 months, no news. Then all of a sudden, we hit the jackpot. Gawker scored with royal breast in this month, Hulk sex. Right? We look at number 122. And Denton asks his editorial team, October 13th, 2012, man. 2012 October is the month to talk about traffic because he's got Hogan and Middleton up there on the site. Have a thought. If there were 3 stories over the years that defined your site, what would they be? A.J. Delario, editor-in-chief of Gawker, says, Hogan initial post. $10,000, right? I am sure they did this with the defining post of their website for $10,000, like Iran said. Look at number 448 and 449. We're so excited about it that Nick's going to tweet to his followers. This is October 2012, 6 days after they put my client's private moment up on the internet for the world to see. In the last month, Gawker.com has had its 2 biggest days ever, each with over 1 million people from the U.S. alone. 6 days afterwards. We're excited. Yeah, I'm sure Denton didn't know that the Hulk Hogan sex tape was going up. Look at the graph. Spikes are important. Everybody has said it. They set a new line. You know, when they talk about the dip after the spike, imagine the dip if there wasn't a spike. That's kind of the point we made. This is the day after the tape was posted. Right? That's attached to his tweet. If we look at number 61, a year later he does the same thing, including in the timeline the month of October 2012 with royal breast and Hogan sex. And then we can look at number 130. This one, yeah, we'll go to 130 now. The 100 most popular Gawker stories of 2012. Hogan's listed is, I think, number 3 there, but in between Hogan and Middleton is the Adam Lanza story. And so, from there, where do we go? We go to number 81, which is Nick Denton on Gawker moving to uniques, right? We've shown this a lot. I mean, y'all have seen this a dozen times probably in this trial, and what the point of it is this is him actually saying that unique views is how we're going to measure things. It's certainly how he measured his investment in other companies. I look at traffic. The idea that he doesn't look at traffic and that traffic isn't the defining metric, for lack of a better word, is just sort of absurd. I mean, it builds brands. They're building a brand, and that's what Anderson talked about here, was that the idea that part of this was the growth of the company, and then you saw the financials. I don't know if you remember that from Kidder, and some of the stuff may have gotten a little boring, but the revenues are going up every year. They're moving into their new space, their $3 million, a year space on Fifth Avenue. So I want to talk to you a little bit about Anderson's testimony at this point and some of the damages issues in this case. Now what Mr. Anderson did was evaluation over. In other words, just like, maybe may apply like the real estate world or something, he used comps. And he takes the comps and he says, what are the monthly unique users, right? And then the company value, and then basically gets a multiple. It doesn't take the high or the low, it takes the average of 19.34. That's the multiple between the monthly unique users of these sites. The correlation to the value of the company. Because what he's doing is valuing the business, telling you what's going to work. And then from there, he's telling you how do you attribute that, relate that back to this event, this tape, right? And this posting, the traffic generated. So, from that, if you see that, he took this 19.34 before I put this down, right there in the middle, right? That's the multiple he used. Didn't use the high, didn't use the low, took an average. From that, he does this valuation. Does the trailing 12-month average, the trailing 12-month average monthly uniques. He uses the evaluation multiple right here, the 19.34, and then it takes the value just like we did on the board with the comps, and uses that to get a value of Gawker.com from before the posting to after, right? And you see this change, $54 million, okay? The total unique page uses video count and the months it was posted, so he uses that to extrapolate basically over 6.71 months how many times it was posted, or unique views. And then the change in the trailing 12 months, average monthly uniques to Gawker, and the average monthly views, it takes a percentage. So what he's trying to do is take this and see the change in phone money in Gawker, and then the change in the value of Gawker, this $54 million, the company's from $281 million September 30th, 2012 to $285 million in April 30th, 2013, after this 6-month period, right? He takes that change and he says, okay, this is the percentage attributable to it. We're going to multiply it times the change in value, and we get that. You see this $15,445,000 number. It sounds like a huge number. But it only sounds like a huge number until you understand the fact that their own expert tells you probably as much as anybody, it's in that world of website traffic and advertising, it's really not. If you could pull up, I think it's, which one is it, number 100? We see this number 100, right? And this was Peter Horan's own company. Their expert, not our expert. And I want to use this to illustrate to you why a $15 million number of change can be attributed just to one defining post. They've recorded a drop. This is about.com. This is the company who reportedly turned around. From 61 million unique users to 52. So they lose 9 million unique users in about.com. This drop resulted in the New York Times, who purchased the company, having to adjust the value, make a goodwill write-down of $195 million. 9 million less viewers, $195 million. So when you take that and you look at Mr. Anderson's number of 15 million attributable to a post that was called a defining post of the website, and you see this change of about 5 million unique users, it makes sense. And although the number's a large number, we look at it and we say, wow, that's a lot of money. Not so big. Not so big, man. 9 million unique users ends up being $200 million in valuation at about.com. That's the world that these guys live in. It's the world, their economics, and what they created. Interestingly enough, if you pull up number D365, John, in the month of October, when this goes up, and this was Horan, it was 20% of the revenue. Remember, he was trying to do the standing thing again. The revenues went down, obviously, the server was down. But this is 20% of the revenue for that month arising from the video they posted on my client. So, we're going to go through the verdict form in a second. I'm going to take you through this. But I want you to remember Anderson's testimony and what he considered. And it wasn't just the impact and the spikes from the traffic, but the greater value to the brand. And I asked Denton about it. I said, it's your brand. You want to build your brand. That's what they want to do. And when you put something like this out there, what it does is get everybody looking. And now they've heard a little more about Gawker. And the throw off to the advertising, the value is exactly what Anderson talks about. And that's how we get to that 15 million. If you look at our second category of damages, if you could pull up 161, 162, and 217. I thought we had them on one board, John. We'll do them one at a time. All right, this was Shanti Shun. And what he did, so the 5 million that you get from Anderson are just off of Gawker. That's Gawker, the views on Gawker. I don't know if y'all got that. Then we bring Mr. Shanti Shun on to talk about, there we go, the other places that went, because it got linked to all these like porn sites and stuff. So who else saw it, right? Who else linked off of it? Because these claims for using Mr. Belay's likeness and stuff have value. Listen, it's kind of a hard thing for y'all to figure out because we're here and we're upset about this privacy issue and so forth. But once it's out there, this is what the law tells you it gets. 10 more till there. Oh, okay, 10 more till 10. Got it. Thank you. Here. So I don't know if y'all remember this, but these are all the different websites, right? He just did a gross count, as much as you can catch. And listen, he was very open about this, and he conceded the fact that, we caught what we could because he had a screenshot. We'll live with this number. This is everything that could catch off that data and what he could get at the time. But YouTube counts are 99,000 and change. All these porn sites that took it, 4.4 million and change. And then this, I think this was a Google Analytics thing with another 2.5 million views right there. And we add these up and we get this number. Okay, those are the views. Remember, Gawker user over here, one category, branding, Jeff Anderson, the change in value to Gawker from the views it got, the hits it got. Second category of our damages, 7 million hits outside of that, all right? But where does that really leave? I mean, what do you do with that $7 million number? Could you bring up the Blatt, I think it's, do you have the 495 page? If we can't find it, I'll just talk about it. You remember the fact that we put this testimony on this guy, Kevin Blatt. I keep him Walker on my board. He showed you what the minimum cost would be on a celebrity website to view this, right? VividCeleb.com or something like that, and it was $4.95. That's what he can find for a 4-day trial membership. We have to use that to judge. It's the best we can do because it's the only evidence we can find of what is somebody going to pay to see this on paid sites where somebody actually has control over their image, right? What would they do? What barometer can we use to tie that 7 million we just had up there? And Mr. Blatt told us that's, the minimum. Here we go, right there. There we go. Remember that? And that's just the way of tying the number. And to be honest with you, when you go back there, you can, ultimately, you have the right to find less or more. I mean, the bottom line is this is the only barometer that we could use, the only measurement of what it costs when somebody puts something out there where they actually have control of it and they want it to be, put up and they want to make money off of it. Now, listen again. This is Mr. Belay and us basically playing the cards that they dealt us in the sense that they put this out there and all these porn sites got it for free. But he's entitled to compensation for that. It's his image. The other thing I'm going to talk to you about, with respect to this, talking about Gawker and them driving traffic shows you the benefit they got from it. That $15 million is the benefit Gawker got from this, and Mr. Anderson was very clear on how they got there. Shanti Shoon's 7 million hits times 495s is what he was deprived of. All right? It's what he was, the opportunity that was taken from him if he had been one of these people that had chosen to actually sell this thing out there on the market. The last category you're going to see on the verdict form, you're going to deal with emotional distress, and I'm going to tell you right now as we go through the verdict form, I'm not going to give you guidance. I'm going to let y'all consume the evidence that you've seen, and if you think my client's ultimately entitled to emotional distress damages, you're going to pick that number, and I'm going to tell you to reflect on one thing. This icon, this giant of a man, this all-American character that surfs on tiger sharks and has changed an industry, was the same guy that Jules Wortman saw crying on Kathy Lee Gifford's shoulder backstage when he found out about this. And I can't tell you that he's the kind of guy that's going to crack on a witness stand and start crying at you, but I can tell you that we can get you real-time evidence of what this did. And if you have any doubts about it, look at his face on the Howard Stern show before he found out about the whole Bubba part on TMZ. I'm talking about the Howard Stern interview he did on the Bound for Glory show. And look at his face. Look at it. I don't care, if you don't want to hear the Welsh again, fine, but maybe you remember the image from trial and how beaten down this man was. All right? I want to go through this verdict form with you and try and explain it to you, which it's, I don't think, nearly as lengthy as a jury instruction. I'm going to go a little over. Are you okay? I'm going to wait for you. You good? Okay. You're going to go back there when you're done. I'm going to get to talk to you again. I get to do a rebuttal, so I'm going to try and wrap up now and come talk to you after Mr. Sullivan does. When you go back there, you're going to get this verdict form. And it tells you basically the questions that you're asked to answer. And it matches up with the jury instructions. It's kind of an elegant process, right? The judge instruction, the law, and those elements get put in here. Did plaintiff prove that by posting the video, this is question 1 on our claim for publication of private facts. Did plaintiff prove that by posting the video, defendant publicly disclosed private facts about plaintiff in a manner that a reasonable person would find offensive? Yes. I've argued to you why. I don't want to go back through it all again. But the standard is whether a reasonable person would find it offensive, and we know the facts are private. There's not a shred of evidence that these facts were not private in this case. And they knew they were. Did plaintiff prove the video was not a matter of legitimate public concern? Okay? This one gets tricky because this is us proving it's not legitimate public concern. So don't let the wording, it's a yes answer. I go back to the board I showed you right over here. And I don't know what better evidence we can give you than A.J. DeLorean admitting that the 10 reasons they said this was a matter of public concern and therefore newsworthy. It's the same thing. Legitimate public concern and newsworthiness are the same jury instruction, right? Just different terms. I don't know what better we could do than having the guy who actually wrote it admit to you that he had not one of the reasons that they said was newsworthy in his mind. You can't get better than that. I mean, he conceded every single one of those elements. And so the answer to that is yes. Did Nick Denton participate in posting the video? I will tell you this. From the culture he set, to the ethics he required, to the rule breaking he demanded, to the conversation on the fire escape, and the mystifying attorney-client conversation we'll never know about. He participated in manning and he bragged. If you want evidence that he participated in, look at his reaction afterwards, real time. Not what you heard in court, but the real time, the tweets, the emails, the defining story. The answer is yes, and then you proceed to question 4. This is our invasion of privacy count. Did plaintiff prove that defendants wrongfully intruded into a place where he had a reasonable expectation of privacy? I don't think there's a lot of places in the world that Terry Millay testified he could be private, but a bedroom at a friend's house was one. And there's no evidence that he had no reasonable expectation of privacy there. Did plaintiff prove that the video was posted in such a manner as to outrage or cause mental suffering, shame, or humiliation to a person of ordinary sensibilities, this common thread of the reasonable person, the decent person, ordinary sensibilities? The answer is yes. John, leave those all up together instead of doing one by one, okay? Did plaintiff prove that defendants used plaintiff's name or likeness for a commercial advertising purpose? This is where they're going to say no. But we didn't prove that because they didn't actually put ads on the page. Notwithstanding the fact that Denton and every other witness conceded that you have to have unique views to get advertising products. We show you that evidence. I'm pretty sure you've seen all of that and appreciate it. The idea of this is not whether they put just an ad on that page. The evidence is clear on that. The answer is yes. Did plaintiff prove that he did not authorize the use of his name or likeness? I mean, of course, there's no evidence to the contrary in this case. We go to our 4th claim, intentional infliction of emotional distress. Did plaintiff prove that the video was an extreme? We go again to this person of ordinary sensibilities. Did plaintiff prove that defendants intended to cause him severe emotional distress or acted with reckless disregard? Reckless disregard is a word we hear in jury instructions, or you've heard, and you see on the verdict form. Reckless disregard, people joking about it. There are people not calling like responsible journalists would. There are people making fun of it and then writing that disgusting narrative that Delario wrote. This is reckless disregard. This case defines reckless disregard. Their conduct is reckless disregard, and it couldn't be any more reckless. Every witness, by the way, was asked, if you knew it would cause him severe emotional distress, would you have done it anyway? And every one of them said yes. Let's go to the 5th, the bottom of that. And then again, this goes to what I was just talking about. You be the judge of that. You saw Mr. Belay on the witness stand. You saw some video. You gauge how severe the emotional distress was. We can tell you that he told you to turn his life upside down. You saw him. You heard about him crying. If we move on, John, to the next page. This is an interesting claim. It's our 5th claim. This relates to the fact that they knew there were verbal communications on the video, and they knew it was recorded secretly and did it anyway. Used or disclosed the video. Did he have a reasonable expectation of privacy and have reason to know that he was recorded on the video without his knowledge or consent? There's no evidence that he knew or had reason to know. They talked about these security cameras, but it's very clear the camera was hidden. You heard Heather Clem's testimony that there was no discussion about it. And you heard the plaintiff say, you know, when he asked Bubba about it, and Bubba said no. There's no evidence that he knew or had reason to know. There's no evidence about the camera being supervision. David Rice, the guy who installed the camera, testified. I don't know if you remember. We did a deposition, a reading thing. Guy on the stand, he read the guy's answers. And he told you that the camera was behind this motion detector, and we showed you a picture of it. It's hidden behind this motion detector. So move on to the next one. That's 110. I'm going to go over by 5. As the plaintiff's only claim, did they act in good faith? I mean, of course not. They told you they didn't care. They told you they didn't call anybody. They knew that Mr. Balea had actually claimed that whether they believed it or not doesn't matter. This is good faith. Delario puts it in his article. He claims it was secretly recorded. They never called anybody. Anybody on the video to ask him. And so that would be good faith. They've admitted they didn't do that. If we go to the next page on this, our damages number. What you see here, $50,378,342.95 combines the two numbers I just talked about. The $15 million from Mr. Anderson, which was the change in value to Gawker, and the $495 times the other views that Mr. Shinn talked to. The number is obviously a big number, but when you compare it to the world that this is in, and these numbers and the values of these companies, remember Aboran's testimony in Mr. Godowski on Cross. He spent $100 million on an advertising campaign for, I think, About.com that did not generate him one view. I don't know if y'all remember that testimony. So when you see this number and you compare it to the numbers that are thrown around in the big internet business world, really not that big of a number. It's big to the common man, but in their world, we're dealing with 200 millions. $100 million advertising campaigns that don't generate a dime of collateral revenue. And so the $15 million I've walked you through, this $495 is the only measurement we really had, and that is what do people pay to see this kind of stuff. And so you see that number right there. And if you pull to the second category, Jeff, there you go. I'm not putting the number up there. That's for y'all to determine at your discretion as jurors. You can make it bear some relation if you want to anything. It's really your view on how my client was distressed, on what this did to him. It's your view of how candid he was about what it did to his life. It's your view of what it meant for a guy like this, an icon of American culture, to be crying backstage at the Today Show with Kathy Lee. You know, I'm going to talk to you about punitive damages real quickly. And I'm just going to tell you all this. You don't talk about a number for punitive damages until you get to a point where you think that Gawker and AJ and Nick need to be punished for their conduct. We've told the story as good as we can. And I've told it as much as I can in the hour and 10 or now hour and 15 minutes that I've had, okay? I can't do any more justice to it. I can't do any more justice to what it did to this guy. At its core, this case has never, ever, ever been about anything more than the fact that Gawker took a secretly recorded sex tape of my client in a private bedroom performing a private act and put it on the internet. It's never been about more than that. It's been about that direct, absolute violation of privacy that is carved out as one area where it becomes a morbid and sensational prying into his life. The one place this guy having given up is these little areas he's carved out. And it can't get worse than this. And we would tell you that punitive damages are warranted, that you should check those boxes and give us the opportunity to get to the next stage of the case. Lastly, I want to end with number 49 and 119. And it's where we started, and that's a cease and desist letter. Are those the right numbers, John? The email too. just put them side by side. And I just want to visually kind of remind you all that again and just say one thing to you. Back in October of 2012, when Nick Denton said that this wasn't persuasive, this cease and desist, right? That was his word. It wasn't persuasive. All of this could have ended. It could have been done, all right? All these guys had to do was the decent thing. And none of this happened. And so to the extent they want to come up here and say $50 million, and oh my God, Mr. Balea, I just want you to go back to what Mr. Vogt started this with and what the common theme was throughout the evidence, and that is this. The power of the media to do great harm and the profits that come from it. And there was nothing more at play in this case on Gawker's behalf than that, and it was how much money can we make taking this private act. So when you go back there, it's a lot. I know y'all have been here for a while, and we've been together on this journey for 3 weeks. Go through the judge's instructions and render a verdict for Mr. Balea. We've walked you through the amounts, and let's get to the punitive stage and let's get some justice done here. Okay? Thank you guys for your time.
Thank you, Mr. Patel. All right, before you get to the defense, we're closing arguments in the sake of all tenure and comfort. Thank you.